Translation? Order. This is the 21st meeting of the Standing Committee on Access to Information, Privacy and Ethics. Orders of the day pursuant to Standing Order 1083H6, study on allegations of political interference into access to information requests. Our witnesses today, our witness is from the House of Commons, Mr. Rob Walsh, Law Clerk and Parliamentary Counsel. And colleagues, he asked and I've agreed to allow Mr. Greg Tardy, Parliamentary Counsel, to also be at the table to assist in the provision of information to the committee members. I would just indicate to the committee that there is a matter going on in the House which may trigger a half-hour bell on a vote. I thought it would happen earlier, but it hasn't, so we're going to carry on as long as we can, and maybe we'll get through this. It has to do with the Afghan detainee documents, and there's extensive debate going on at this time. So, welcome, gentlemen, to the committee. As you know, the committee has been conducting a study, and as a consequence of some of the matters which have transpired during this study, the committee requested that you appear to provide us with information to guide the committee or to answer questions with regard to parliamentary or, in fact, legal ramifications of failure to appear before a committee, whether it be on invitation or even by summons. So, having said that, Mr. Walsh, I would, and Mr. Tardy, I would entertain any brief opening remarks that you care to make to put some context to your role or to provide information to the committee. Please proceed.
Thank you, Mr. Chairman. By way of explanation, I would add that I asked Greg Tardy to join me as he monitors these kinds of things in the office on a daily basis, and I thought he might be able to fill in some of the gaps that I may inadvertently leave. Speaking generally, I do not have a prepared statement of a kind that might be distributed, given that it was only the end of the day on Thursday that I was asked, got notice to be here. But I can speak generally, Mr. Chairman, to the following effect. With regard to the consequences that might flow from a potential witness failing to attend when invited in one instance and when summoned in the other. The answer in the first instance is very short. Where they're simply invited and they don't show up, you might say, well, that's not very nice, and then you have to go to the next step. It could be an accident or an inconvenience or whatever that caused the person not to show, but it's not necessarily something to be taken seriously as a matter of procedure. However, when the person is summoned by the committee, then push is coming to shove. Then if the witness does not attend, there are steps that the committee could take for the failure of the person to attend pursuant to the summons. Those steps essentially are ones of reporting to the House, and the report should set out in some detail the events as they transpired, and once that report is in the House, then it's available to the chair on behalf of the committee, any member of the committee or any member of the House, arguably, to rise and raise a point of order or a point of privilege, as the case may be, based on that report. In the absence of that report, with such a point of order or a point of privilege, the Speaker has nothing to which he can refer or take into account, and so it is essential that there be a report of the committee to the House as a first step. Now, I suppose of interest to committee members is then what? Well, then what? You get into to some degree, uncharted territory. If a point of privilege is raised in the House based on the report of the committee, the privilege point presumably would be that the person in question failure to show up pursuant to a summons was a contempt of the House and its committee, and that point would be argued, and if the Speaker were to rule that prima facie it is, a motion could be made. Now then, what's in that motion? Well, the motion could be that the person be directed to appear at the bar of the House and explain why he or she did not attend pursuant to the summons. On the other hand, it could be that, first of all, the motion could be that the person be not found in contempt, but be called to appear before the bar to explain why he or she did not attend, and there could then be a motion of contempt following that depending on whether the House was or was not satisfied with the explanation provided by the individual. On the other hand, the motion could be one of going directly to contempt without calling upon the person to appear before the bar. And then there are what you might call extra parliamentary avenues, which I mention because I must as a legal advisor, but they are fraught with complications and improbabilities, such that I wouldn't put much faith in actually ever going that route. And particularly, I'm talking about Section 139 of the Criminal Code, which applies to proceedings of the House and the Senate, and where a person interferes in some manner with the proceedings, so as to obstruct justice, interfere with a witness, whatever. There could well be proceedings brought against that person. It may not be the person who didn't show up pursuant to the summons. It may be some other third party who was instrumental in causing that person to not show up. But you must remember, with a criminal charge, you're faced with some very strict evidentiary burdens, one of which is that the person had the intent to interfere or obstruct the proceedings of the House in undertaking the actions that he or she did. Of course, you would have to prove that there were such actions undertaken with that intent in mind. There's also, and I don't want to raise unnecessary red flags here, but there's also the legal argument in such a prosecution where the person, let's suppose for a moment whether it's a member of Parliament, a Minister of the Crown, or a third party who is charged with this obstruction of justice, could argue that the actions that individual did were with lawful excuse as a defense. And I know I'm not unaware of the fact that this issue has been discussed in the context of the position taken by the government that political aids to a minister can be withheld from a committee as witnesses by the minister, insofar as the minister is responsible to account to Parliament, not the political aid. Well, that rationale could be used or argued as a lawful excuse for why it is that the minister, if that were the case, gave directions to the witness to not show up. Would it survive the test in court? Well, I would argue that that issue would need to be dealt with by the House before the matter went to court. And the House would have to decide whether that is or is not a lawful excuse. And then the package that would go to the court, sorry, it wouldn't go to the court, it would go to the Attorney General for Ontario, the Crown Counsel Office, would include the record showing that the House had made that determination. If the House said it was a lawful excuse, then presumably there would be no reference for purposes of a prosecution under 139. If the House had said it was not a lawful excuse and they felt of the view that there was an interference of the kind to which Section 139 applied, then directions would go to the Crown Counsel Office where there is a discretion. And that office may feel, on the information they don't have enough evidence to probably obtain a conviction, and they may choose not to prosecute. So it's not a matter entirely in the hands of the House as to whether there is or is not any extra parliamentary legal remedy available to deal with the situation of a witness not showing up. Primarily, it's a matter for the House to deal with as it relates to its own proceedings, and once as I say, the procedure goes forward in the House, it's a matter of debate and a matter of a vote at the end of the day. Well, first of all, a ruling by the Speaker prima facie, and if there is such a ruling, then it's a matter of debate and a matter of a vote in the House as to what the outcome would be. But that's the extent of my opening statement, Mr. Chairman, as to generally what's the consequences of a person not attending as a witness when summoned. There are no significant consequences to talk about when they don't show up, when they're only invited, as I said. But certainly when they're summoned, there can be consequences, but largely of a parliamentary nature as opposed to an extra-parliamentary legal nature.
Thank you, Mr. Walsh. If I may, it might be helpful to the committee if you could just amplify just a little bit. As you know, committees are fact finders, and this relates to the evidence, and you referred to evidentiary burden. Can you just give us an idea of the scope of things that would constitute evidence for that purpose?
Well, the best answer there is to actually, for a moment, if I could, I'll take a look at Section 139, where it sets out what's required in terms of the evidentiary burden, as you call it. In any criminal offense, of course, you have to prove that the person did the deed which is prohibited by the criminal code provision. This provision, 139, provides that everyone who willfully, we'll come back to that in a minute, willfully attempts in any manner to obstruct, pervert, or defeat the course of justice in a judicial proceeding by, and it sets out two possibilities, by indemnifying or agreeing to indemnify a surety, and that's 139.1, which really doesn't apply to members' situation we're dealing with. I should read subsection 2. Everyone who willfully attempts in any manner other than the manner described in subsection 1, because that deals with sureties, to obstruct, pervert, or defeat the course of justice is guilty of an indictable offense and liable to imprisonment for a term not exceeding 10 years. And then in subsection 3 goes out to offer some illustrations of what that means. It says everyone shall be deemed willfully to attempt to obstruct, pervert, or defeat the course of justice who in a judicial proceeding, which by the way is defined in the criminal code as including a committee proceeding, who in a judicial proceeding existing or proposed, A, dissuades or attempts to dissuade a person by threats, bribes, or other corrupt means from giving evidence, B, influences or attempts to influence by threats, bribes, or other corrupt means a person in his conduct as a juror, and that doesn't apply here, or C, accepts or obtains, agrees to accept or attempts to obtain a bribe or other corrupt consideration to abstain from giving evidence or to do or to refrain from doing anything as a juror. So, as a matter of interpretation, one of the problems that language suggests to you is that when it says threats, bribes, or other corrupt means, you have to be thinking in terms of corrupt threats, corrupt bribes by definition are corrupt, I suppose, or other corrupt means, as opposed to a conversation that might take place where remarks are made of a kind to the witness about whether he or she should think twice about attending. Those kinds of remarks may be characterized, I'm saying, as not being corrupt, but the further evidentiary problem goes back to the use of the word willfully. Were those remarks made with the intention of trying to prevent the person from appearing in front of the committee? And those are the evidentiary burdens. You have to prove that. You have to prove, in my view, that the corrupt nature of the interference and that it was willfully intended to interfere, as opposed to some remark made in passing, which, taken out of context, would not support that kind of a charge.
I think that's helpful to the committee. Okay, we'll go to the questioning. I have Mr. Easter, Mr. Freeman, Madam Freeman, and Mr. Sixay. Mr. Easter, 7 minutes.
Thank you, Mr. Chair, and welcome, folks. Oops, there you fell overboard there, Judy. Anyway, as you know, Mr. Walsh, we are having, I think, considerable difficulty as parliamentarians getting at least 3 witnesses before this committee that we believe it's very serious. That in order for us to do our duty to Canadians and gather informations on the actions of certain people within the government that do indeed work for ministers, and in one case the Prime Minister, that we really believe that we need those witnesses in order to do a proper inquiry into the information needed for us to make some decisions. And as you're also aware, there's the ministers and the government are taking, I believe they're using the excuse as ministerial responsibility to prevent them from getting here. And I basically pegged this that what's happened now is that these individuals seem to be in a conservative witness protection program to prevent us from getting access to them. In any event, I have a couple of questions on the, and you've touched on it in your remarks, but what basically are the penalties for failing to appear before a House of Commons committee when issued with a summons? I mean, I guess the irony here is one of the people that we've issued a summons to hasn't been able to been served the summons, even though he shows up most nights on the media as the key spokesman for the government, that being Mr. Dimitri Soudis. He's out there in the media, but we can't access him to serve the summons. So that's a very difficult situation. But what are the penalties for not appearing when we do issue a summons?
Well, Mr. Chairman, I would first choose not to use the word penalty in this context. Penalty is more like a sentence a court might hand out upon conviction for a fixed term use in prison. Rather, the powers the House has are ones it might exercise to try and induce compliance with the order of the House. So assuming for a moment the matter advanced where the House made an order that the person show up and testify before the committee, and the person didn't, then I think the House might send for the person to be apprehended and brought before the committee to testify. And then if the person on that occasion did not testify, the same order would say to be held in custody until such time as he or she does testify. Now that's been done in the past, and they're held in custody, but they're released at the end of the session. But the point being, in my view, is that the reason for the imprisonment is to induce compliance, not to penalize in terms of sentencing them for a period of months or years. Once they comply, i.e. are ready to testify and do so to satisfaction of the committee and in turn the House, then that's the end of the incarceration and the person goes home. So in terms of trying to enforce its proceedings or defend its proceedings against improper or contemptuous conduct, the extreme end, I suppose, is to have the person, by order of the House, directed to the Sergeant at Arms, incarcerated until such time as the person does comply. And upon compliance, then presumably they would be released because there's no further need for the imprisonment. Pardon me?
Is that by Speaker's warrant?
It would be, indeed, by direction of the House.
Yeah, it has to be directions of the House. That'd be interesting if we put leg irons on the Prime Minister's key spokesman, wouldn't it? The other difficulty here, though, is in terms of the individuals that this committee wants to meet with. We really don't know whether they willingly want to come or don't want to come because they've been ordered. I mean, the Prime Minister's letter to the clerk of the committee, in this case, said the purpose of this letter is to inform the committee of my instruction to Mr. Soudis that he will not appear before the committee. So we have the strange situation here of the committee asking for certain witnesses, and we've added one to our original witness list because of what Mr. Togneri said before this committee. When that happened, there seemed to be a move to prevent these staffers from coming before committee. So we really don't know whether they willingly want to come, and they're probably aware of the severe penalties for not coming under summons. But they're being ordered to by their masters. So where's that leave us? If you have a situation where the witness may want to come, but is ordered not to come by their superiors, I mean, this is unique when it is the Prime Minister who's exercising the cover-up, but it's a unique situation.
Mr. Chairman, I haven't seen that letter to which the member is referring, but I can understand what it says from what he's read. It is not the case, in my view, and this is supported by the Speaker's decision of April 27th on the Afghan detainee matter. It is my view that the same rule applies with regard to a committee's entitlement to get documents as applies to the committee's entitlement to have persons appear before it. It is not the case that anyone, with 3 possible exceptions, has a right to not attend when summoned by a committee. Those 3 exceptions, as you may know, are members of Parliament, senators, and perhaps the Governor-General herself. But apart from that, anyone summoned to appear in front of a committee has the obligation to attend. Now, the next stage, however, is where the rubber hits the road. What questions are you entitled to ask that person who does appear in front of you? It may well be the case that when it is the case, as you well know, that a public servant appearing before a committee, and they do this quite frequently, is not to be asked questions relating to ministerial policy, government policy, or expected to defend ministerial policy, government policy. They are there to respond to administrative matters of interest to the committee. Well, in a similar fashion, while I would be of the view that a political staff of a member of Parliament is obliged to attend when summoned and is not necessarily excused from not attending by virtue of a direction from his or her minister or the Prime Minister, nonetheless there may be limits to what questions you can put to a political aide. And I would say that analogous to the situation with public servants, so also with political staff, you might use what the lawyers call the best evidence rule, and that is, if what your question is looking for is a matter that the minister can answer best, that's the person to whom the question should be put. On the other hand, if your question is something that the aide can answer best, like a matter of fact, were you on this day at this meeting and did you engage in that conversation with so-and-so, or did you? Those are matters of fact, and no one knows those better, arguably, than the aide himself or herself.
Thank you. Madam Freeman, please.
Monsieur Walsh, je voulais vous remercier d'être ici ce matin.
Thank you for being here this morning, Mr. Welsh, to shed some light on these various matters regarding the non-appearance of certain witnesses. I know that in one of the opinions that you gave on the 24th of September on Public Works, you explained that the committees and House have a function of forcing the government to be accountable. At the moment, there is agreement that the government must be accountable for what it says and does. It must be accountable. That's one of its obligations. At the moment, we realize that we're having a great deal of trouble getting information, getting all sorts of different things from this government. And I would like to know this. Who has priority, the executive arm or the legislative arm, or the powers of the committee or the powers of the executive? Mr. Chair. In theory? Well, there is a theoretical answer and a practical answer. From the decision of the Speaker on the 27th of April, the House of Commons and its committees are entitled to get everything requested by the House of Commons, but because it is fundamental to the relationship between the government and the House of Commons, or in which the government is responsible to the House of Commons, and the government must give all necessary things to assist the committee or the House to do what is required in order to be accountable to the government. But in practical terms, there is a relationship of trust between the government and the House of Commons. And at the end of the day, it is a political issue. If the government says no, it's up to the House to decide whether or not it will accept that answer, or whether it will move contempt of Parliament. In the end of the day, in my view, we could talk about parliamentary principles and legal principles, but ultimately it is a political issue between the House of Commons and the government of the day. So if I understand correctly, despite the statement that was made by Mr. Milliken, his ruling last April was reference to the Afghan detainee document. The Speaker power can only be limited by the House of Commons. At the moment, the executive can disregard that. Yes, theoretically, but he's right. The Speaker is right. But at the same time, if the government decides to say no for political reasons or for whatever special reasons it has, it's up to the government to say that. But it's up to the House not to accept the answer and to present a motion of contempt of Parliament. because not a question that can be referred to the court. It's one that involves Parliament only. Two other questions then. Can a minister or a prime minister can tell a member of their political staff not to comply with a summons to a committee? In theory, no. Under page 1076, we say that parliamentary privilege cannot be called into question in that case. That's right. Parliamentary privilege is not limited by a decision of the government not to send a document or not to provide a witness to a committee, because it is necessary for the constitutional function of the House and committees to have all documents and witnesses it requires that could assist the House or the committee in being accountable to the government. So if you say that a minister or prime minister cannot tell one of its aides not to appear, what recourse do we have against the minister or prime minister in such a case? Well, I think that the committee makes a report to the House on the matter, and if the facts are demonstrated by the committee in the report, then there would be a motion in the House stating that the minister or the prime minister acted in a contemptuous way or showed a lack of confidence, in such a way that there was a lack of confidence in the government. And if the House is in agreement, then it's a question of confidence in the government. Outside of that, I think it's difficult to find ways of implementing the committee's order against the government in any criminal way. It's difficult to imagine any measures that would be taken against the government. Thank you. Thank you, Mr. Walsh.
Thank you, Chair, and thank you for being here today, Mr. Walsh, and for bringing Mr. Tardy with you. As you know, I was of the opinion at the last meeting that this was probably an unnecessary visit. It strikes me that the facts of the situation are absolutely clear, and nothing that you've said this morning has dissuaded me from that opinion. This committee has invited and then summoned 3 people related to a study that we were undertaking. They have refused to appear. And I think that's a very, very serious issue, and goes to the ability of this committee to do the work that it has decided is important. We know that those folks were advised not to attend or ordered not to attend by a cabinet minister and by the prime minister, which I think also goes to our ability as a committee to undertake the work that we believe is required. And you've made it very clear that our next step is to report that to the House of Commons, and then it's the House that takes the issue from there and makes decisions about what has happened here in the committee. And I believe that we should get on with that. This is an issue that I think we've been very generous in the committee. In fact, we've extended the possibility for these folks to appear until tomorrow. In I think an act of extreme generosity that I don't believe was necessary, but the committee in its wisdom decided to do that. So we've in fact given these people extensions to find the time or find the ability to get here to be questioned by the committee. So I'm thinking that we need to get on with this work. So I don't have too many questions for you. I'm finding the conversation very interesting this morning. The what-ifs are very interesting, but I think we need to get on with the work that we've undertaken, that we believe is required, and we need to get on with reporting the failure of these people to show to the House and let the House deal with that issue. I do think that there is an important issue that wasn't covered in the draft motion, and if I can just speak to that briefly, because it has come up as well this morning. I think the issues of the letters from Minister Paradis and the Prime Minister to the committee also needs to be part of what we report to the House. I think those are significant interventions in this issue. The Prime Minister's advice to, or the Prime Minister reporting that he had told Mr. Sudas not to appear is crucial piece of what's happened here. and it could be important for the House to have that information, as well as Mr. Parady's advice to the folks that work for him. I believe that that should be part of our report, and that we should append those letters in terms of our report to the House. So just to let members of the committee know that that's something that I'll be pursuing when we get to the discussion of our report to the House. So thank you, Chair.
Okay, I might want to just point out that we're still talking about the template that was suggested by the Clerk's Directorate, and I think what's been happening in the last couple of meetings are basically to help the committee determine what a report might look like, and I think Mr. Walsh has raised some interesting questions that the committee want to consider. Mr. Poilievre, please, 7 minutes.
Thank you. O'Brien and Boss states on page 32 to 33, responsible government has long been considered an essential element of government based on the Westminster model. Despite its wide acceptance as being a cornerstone of the Canadian system of government, there are many different meanings attached to the term responsible government. In a general sense, responsible government means that a government must be responsive to its citizens, that it must operate responsibly, and that its ministers must be accountable or responsible to Parliament. In terms of ministerial responsibility, it goes on, ministers have both individual and collective responsibilities to Parliament. The principle of individual ministerial responsibility holds that ministers are accountable not only for their own actions as department heads, but also for the actions of their subordinates. This principle is further upheld on page 139 of the second Gomery report, which was entitled Restoring Accountability Recommendations, wherein Judge Gomery states, and I quote, "Ministers need to understand clearly that they are accountable, responsible, and answerable for all of the actions of their exempt staff." It's interesting that Judge Gomery did not simply refer to ministerial accountability there in reference to the actions of exempt staff. He actually he took pains to list the 3 forms of ministerial responsibility: accountability, responsibility, and answerability, the last one being the most important. Opposition members have argued that you could have a political staff member who is ultimately responsible to a minister come here to this committee to be answerable to Parliament. In fact, Judge Gomery clearly indicates that that is not a proper definition of the powers of a committee when he says ministers are answerable for the actions of their exempt staff. These principles are long-standing in our system, and in fact, you are a scholar of parliamentary tradition. When did the concept of ministerial responsibility develop?
Mr. Speaker, I think O'Brien Bosk, as you obviously have read the text, Mr. Poilievre, discusses that. I'd just like to first point out, though, that my notes indicate that Justice Gomery took the term ministerial responsibility in quotes and said it has to do with the relationship between a minister and public servants working in the department of which the minister has charge. I'd like to address that, Mr. Speaker. Before I get to that, the first question is, while much that I have heard said about ministerial accountability is true, insofar as the responsibility of ministers, where I differ, you might say, is in the use of that principle so as to enable the prevention of certain individuals to be available to a committee. I don't for a moment question the responsibility of ministers to account both for their department and to account for the actions of their staff, their exempt staff. But I guess I disagree with it saying that that's an exclusive responsibility. It seems to me, as I said earlier, exempt staff of a minister could well be called as witnesses for a committee because they have knowledge of a particular situation of interest to the committee. And while they should not be asked to answer questions pertaining to the minister's personal actions or policies or that sort of thing, they can be expected to answer questions pertaining to their own conduct and their own involvement. And I don't think it's correct to take the principle of ministerial responsibility or ministerial accountability and apply it so as to prevent others from attending it before a committee. But let me go one step further, Mr. Chairman, because I think there's an important consideration here with regard to this principle. It is a pierre angulaire of our system of government, a cornerstone. But in my view, if you read both Mr. Gomery's fact-finding report, I think it is, and including the document issued by the Privy Council Office as a guide to ministers, and other texts, Erskine May, the principle of ministerial accountability rests on the principle of governmental accountability. The government's accountable to the House holds the government to account. That's the whole confidence basis of the relationship. And ministers individually are accountable on behalf of the government. But ministerial accountability is tied to a minister's duties with respect to his department. Because you must understand that ministers are vested by statute with various powers and authorities of a legal nature. That's when they act as government. And so for the people of Canada, it's important in our system of government that the House of Commons is there to question the government on its governmental actions, exercising public authority, public powers, and so on, where these might be exercised in poor judgment or improperly or whatever. When you get over to ministers' offices and political staff, they are treated separately. Even in the Privy Council Office guide to ministers, that's a separate consideration toward the end of the document where it states that ministers are individually, personally responsible for their staff. That's no question. As members of Parliament are individually and personally responsible for their staff. They're the employers. But I don't believe it falls within the ambit of the principle of ministerial accountability as we know it as a constitutional term to talk about ministers being accountable in that context for political staff. Political staff are not in a position to direct the public servants to do anything. They don't exercise any authority on behalf of the minister. It's the public servants who exercise the minister's authority on behalf of the minister. And in that sense, they come to committee and they answer matters that they're undertaking in the department on behalf of the minister. But even there, the minister can still be called to explain his department's actions, as the minister can be called with respect to his political staff. The minister is fully responsible for answering for all these matters, but I don't know that I can agree with the argument that that principle has the effect of making the minister exclusively responsible to answer for the business of his office and to answer for his political aides.
I do think we've strayed.
That's 7 minutes, Mr. Polyev. I'll have to go to Madam Foote, please. 5 minutes.
Thank you, and thank you, Mr. Walsh, for being here, and Mr. Tardy for accompanying you this morning. I certainly found the exchange to be of interest, and I know that you indicated you had not seen the letter written by the Prime Minister, signed by the Prime Minister, in fact, instructing the committee that his instructions were that Mr. Sudas would not appear before the committee. Now, I know I can provide you with a copy of the letter if you'd like, but I guess having seen that and having listened to you, is it right to say then that the action that the Prime Minister has taken here is contrary to what your understanding is of what his authority is in terms of preventing a witness from appearing before a committee at the call of the committee?
Contrary to his authority for preventing, I guess my view is the Prime Minister and any minister has no authority to prevent someone from appearing in front of a committee. Their ministerial function may present a limitation on what you can ask that political aide when they're in front of you, but everyone has a duty, apart from members of Parliament, senators, and the Governor General, to show up when summoned before a committee. What questions they can be asked is another matter.
Absolutely. So then clearly what the Prime Minister has done here is not within his authority to do this.
I don't believe so, but again, I haven't read the letter, but the way it's read to me, it reads as if he's purporting to have the authority to direct a person to not be available to the committee as a witness. I don't believe anyone has that authority.
I was interested in your response to Mr. Polyev in terms of the definition of being answerable versus an individual actually answering to his or her actions. And going back to your comment about best evidence and looking at the matter of fact, where the committee wanted to go with these witnesses, in fact, was to have them speak to their actions, information that had been given that we had knowledge of in terms of steps that they had taken. Or let me give an example in the case of Mr. Togneri, who had, in fact, ordered the on-release of a report that departmental officials had, in fact, already released. So from our perspective, from the committee's perspective, it was important for us to have the witness here to answer to his or her particular actions. And I guess my question is, and I guess just to go back to your point on this, is that for a minister to appear before the committee and to expect the committee to accept his answers or her answers in terms of being answerable for his or her exempt staff in this case, that is not proper, and that is not something that they have the authority to do either.
Well, as I said earlier, I don't believe they have the authority to cause that to happen, but it may be proper in the minds of the committee. The committee could well be satisfied with what the minister told them. It's up to the committee to decide who they need to talk to.
When you talk about someone not appearing, I just want to go back to a reference you made. They may be able to, or with lawful excuse. Can you elaborate on that for me?
It's a legal argument that could be used by someone. Well, let's stay with the hypothetical we're talking about now, and I emphasize I'm addressing it as a hypothetical, where a minister is charged with interfering with a witness and preventing a witness from attending it for the committee. The minister's response and defense would be, well, I did that with lawful excuse. My lawful excuse was the principle of parliamentary ministerial accountability enables me to direct that certain persons will not be available to the committee and that I will be the one that's available. Now, would that be a legal argument that would prevail in court? My own thought is it's an argument that should be made in the House, and the House should decide whether that's sufficient. And if the House were to decide it's not sufficient and then the matter go to court, I think the court would be obliged to accept the House's determination. If, in fact, the House did not determine that question and it went to court, the court might say, well, sorry, we can't consider this matter. That's a matter of internal House proceedings, and courts can't go there. So you got to think about those kinds of issues if you're looking at some extra parliamentary legal approach. Generally speaking, with criminal offences, a person may have defences that we generically describe as lawful excuses. The emphasis is not on excuse, but on lawful, exonerating circumstances that are recognized by law to have the effect of providing a defence.
I guess I'd like to ask you as well.
We are at 5 minutes, and it's just over 5 minutes now, so I'm going to go to Mr. Polyev, then Madam Freeman, and then Ms. Davidson. Okay.
One lawful excuse, of course, would be that you're upholding centuries-old traditions by not attending and supplanting ministerial responsibility. And that, of course, would be the lawful reason for the non-attendance of the witnesses in question. While I was disappointed that you didn't elaborate on the longevity of the principle of ministerial accountability, I will bring us to modern day and clarify the words of Judge Gomery in page 139. He didn't refer to ministerial responsibility in a vague sense that could be widely interpreted however one chose. He was very specific. In fact, his words here on that page are incredibly apropos. First of all, he doesn't just use the term accountable. He doesn't just use the term responsible, terms that could be widely interpreted by fair-minded people. He also uses the term answerable. And the attendance of a potential witness before a committee falls under the rubric of answerability. He then also says the terms exempt staff. So he was not speaking in a vague sense requiring broad interpretation by the government. His words are very explicit, highly applicable to this situation. And then he uses the term all. Ministers need to understand that they are clearly answerable for all of the actions of their exempt staff. That would seem to run at cross currents with your interpretation that ministers are only responsible for some of the actions of the exempt staff, and that the exempt staff, by consequence, are responsible for others. The term all, the term exempt staff, and the term answerable make this sentence tailor-made for the circumstances with which our committee is now presented. And that is the basis on which the government has made the decision to instruct staff members, instruct ministers to attend in the place of staff members who've been wrongly called. And it now falls to the committee to accept that ancient tradition of ministerial accountability and proceed with questioning of the ministers in question. And that decision has now been made, and I think it would be in the interest of the taxpayer that we move from this procedural debate, which is resolved, to a practical study of matter of access to information and the way in which it is applied, so that we can, on the government side, explain the actions that we've taken, and on the opposition side, members over there can carry out their function of, their legitimate function of critiquing our approach. So that is the decision the government has made, and those are the principles upon which that decision rests. And we feel very confident that the hundreds of years of traditions behind it support the decision and our actions. Thank you, Mr. Chair.
Did you want to make some comment, Mr. Walsh?
A brief response, only to say that I don't disagree with what the member has quoted, and I could perhaps throw other quotes out as well, but I think there's a misunderstanding of what I said. I agree that the ministers are responsible for all, and the member put references on the word all. All I'm saying is they're not the only one that can be held responsible in front of the committee. Their staff could well be called as well. So to say that they're responsible for all is not to say they are the only ones responsible in the sense of being subject to being called in front of a committee. All I'm saying is that staff could be called in front of the committee, but there will be limitations on the questions that can be asked. There will be some questions that should be directed to the minister that are properly directed to the minister and not to a political staff person.
Thank you. Madame Tillac, s'il vous plaît. Tu as la parole.
Merci, Monsieur Walsh. Merci.
Thank you, Mr. Walsh and Mr. Tardy, for being here this morning. I wanted to ask a question about what Mr. Paradis said, the former Minister of Public Works. When the media told him about a document that was unreleased by an employee, he said that this was a decision that was made by one of his employees and not by himself, that it was the responsibility of one of his employees, and as a minister, he cast the responsibility for these actions on his assistant, Mr. Tonnier. Mr. Tonnier was invited here to appear, and he wasn't released by the Speaker. Is the rule different for Mr. Tonnier because he had started appearing here before the committee? He had not been released by the committee. Would the rule be different for him than for someone who doesn't reply to a summons or to an invitation? Was Mr. Tonnier summoned, or was it simply an invitation to appear in his case? was summoned, then he remains under the committee's orders with respect to the testimony. At the end of the meeting, he would have to come back at the next meeting to continue with the testimony unless the committee decided that he was excused. Since Mr. Tornieri had begun his testimony, and since he had not been released, he should have come back to the next meeting. And if he does not, what are the penalties? What are the sanctions? What are the procedures open to the committee? Because you say it is different. If there's a summons or not, or if the witness hadn't started his testimony. So what options do we have as a committee? We heard from Mr. Tornieri. He started his testimony, and he didn't come back when summoned. So what action should the committee take in this case? In theory, there's no difference. The same principles apply to him as to other individuals who did not attend. There is no difference. Perhaps Mr. Tornieri misunderstood the situation and might have come on a day other than the one he was supposed to come. Errors can happen. But the same consequences apply to him as to any other witness in the same situation. Thank you very much.
For being here this morning. I just want to go back to one thing, and when we're talking about ministerial responsibility and the belief that the government has that certainly there needs to be ministerial responsibility. In Accountable Government, the Guide for Ministers and Ministers of State, on page 37, it states that ministers and ministers of state are personally responsible for the conduct and operation of their offices. And in my mind, at least, that certainly says to me that there is ministerial responsibility. So I feel that ministers are responsible for their departments, and they are responsible to Parliament. And I feel that it should be the ministers that are here speaking for their departments. So could you comment on that, please?
Well, I would agree with you in the sense that the minister is the primary person responsible for what goes on in his or her office. I have no quarrel with that whatsoever. But that doesn't mean that the committee isn't justified in seeking to hear from other persons in the office on particular matters of which they may have direct knowledge. I don't mean to suggest this is the case here, but you might appreciate that if the government of the day can pick and choose what documents it'll provide, or pick and choose what public servants or what political staff shall appear for committees, that has the potential to undermine the ability of a committee or the House to hold the government to account. And so it is that, as in a court proceeding, so also here, the person of whom a demand is made to produce a person or a paper does not have the choice of selecting which it shall produce. But I fully agree with you that ultimately, and maybe not so much ultimately, but at first instance, the primary person responsible for the conduct of the ministerial office is the minister himself or herself.
Okay. Can you help me with the summons issue? Mm-hmm. It's my understanding that the way this proceeded from the committee was that Mr. Tornieri was summoned first and did appear twice. And as you have just talked about, he wasn't released or excused, I believe. So that summons carries on until such time as the chair, or who releases or excuses the person?
In my view, as a practical matter, if a person testifies under a summons and the meeting ends and the person gets up and leaves without being told they're not excused, they're entitled to assume they are excused. Okay? And committees don't customarily get into that formality. The onus is on the committee, I think, to make it clear to the witness, we're not finished with you yet, we want you back at another time. And I think the onus is on the committee to specify when we want you back. And then there doesn't have to be another summons, but there's an onus to now indicate you're expected back for this next meeting, and then the onus is on the witness to attend the second time. But if a witness were to get up and leave the meeting when no one says he's not excused, I think he's entitled to assume he is excused.
Okay, so now then in the instance of a couple of the other staff members that are involved with this, summons have been issued, but it's my understanding that they've never been delivered. So what is the legal status of that? Have they been summoned? Are they deemed to have been summoned, or have they not been summoned?
Well, this phenomenon, of course, is not unknown in the courts, as you may well appreciate,
right.
And the recourse to take is to go to the court for an order. It used to be, anyway. I've been not in the courts for a while. Maybe there's a simpler process now. But you used to have to go back in front of a judge and get an order for what was called substituted service. And then you get an order saying, all right, post a notice in the local newspaper this many days over this many weeks, or leave it at this certain address and that address. And if you do those things, then the courts will deem the person to have been served, okay? Now, we don't have that kind of process here, but it could well be the case that if the committee were to report to the House that these steps were taken to try and effect service, the House, in its judgment, could simply deem the person to have been served. And in my view, that would be sufficient for purposes of the House proceedings.
But it would be the House that would have to do that. The committee couldn't do it. The committee would have to report the sequence of events to the House, and they would have to deem?
The committee could do that, but it would do it at its peril if the House later were to decide that it had acted without properly satisfying itself that the person had been served. So yes, the committee could do it as a practical matter, but I'd be concerned that later the committee may be contradicted by the House, and the House might decide, no, that's not good enough. So as abundance of caution, if time permits, I would recommend the committee go to the House and get the House to deem the person to have been served for purposes of the committee proceedings, and then the committee returns to its business with that order made.
Good. Thank you very much.
Thank you. Mr. Easter and then Madam Block.
Thank you, Mr. Chair, and thank you for the, I think, great information in your capacity as law clerk and parliamentary counsel, Mr. Walsh. I had read earlier the letter from the Prime Minister on Mr. Sudis, but we're dealing with three individuals here, and I'll read you both the pertinent quotes out of both letters. And my question to you, in your long experience here, is have you ever seen this ever happen before of this magnitude? The letter from the Prime Minister to the clerk of the committee, referring to Mr. Sudis, said, I am aware the Standing Committee on Access to Information, Privacy and Ethics is requesting the attendance of Mr. Dimitri Sudis on June 10. The purpose of this letter is to inform the committee of my instructions to Mr. Sudis that he will not appear before the committee. And the letter is signed by the Prime Minister. The second letter refers to the other two witnesses, and it's from the Honourable Christian Parady, the Minister of Natural Resources. And in his letter to the clerk, he states this, and I quote, pursuant to the statement made by the Leader of the Government in the House of Commons on May 25th, and the motions passed by the Standing Committee on Access to Information, Privacy and Ethics on April 1st and May 25th, requesting the appearance of Mr. Sebastian Togneri and Ms. Gillian Andrews. This letter is to inform the committee that I have instructed Mr. Sebastian Togneri and Ms. Gillian Andrews that I will appear before the committee in their place. It's a little bit different letter than the Prime Minister's, but it certainly has the same impact of really disallowing their attendance at committee where we really believe we need them to gather information. So my question really relates to, I think you've answered the impact and the parliamentary procedure to that previously, but have you ever in your experience seen anything like this before?
Mr. Chairman, it's a lot of years since I've seen something that I've seen before in this place. It seems to me everything comes along for the first time. I've like lost my virginity 100 times since I came here. But be that as it may, that's irrelevant whether I've seen it before, because it's the issue's here now. I would say about the second letter from the Minister Parody, that the better practice for the committee, I think, would be hear from Mr. Parody first, since he's volunteering himself to speak to the matter. But that doesn't mean, having heard Mr. Parody's, the minister's testimony, that the committee is precluded from then asking for certain staff to appear before it. But I think the better practice is to hear from the minister first, if the minister is available and is willing to attend.
Our concern in that, and we could be right, we could be wrong, I don't admit that, is we're worried that the precedent it would set in that, and Parody was here, the precedent it would set in that they've now set a standard where if the minister so decides and we ask someone that a minister can come in their place. That was our concern on that particular point. There was one other question I had, Mr. Chair. And you had mentioned it earlier, and Judy asked somewhat along these same lines as well, but are there really any legally justifiable reasons to refuse to appear before a parliamentary committee when a summons is issued? And Mr. Chair, the summons never did get delivered yet to Mr. Sudas, did it?
Well, you might want to ask Mr. Walsh. As you know, it was dated, a specific date, and that date of appearance is now passed. Okay. And I guess the question is whether or not it has any special status, or summons would have to be reissued.
Because as I said earlier, Mr. Walsh, the strange scenario here is you have the chief spokesman for the Prime Minister of Canada, who ends up on TV most nights, certainly more than most cabinet ministers. Yet he couldn't be found by the bailiff to issue him a summons, even though they called the receptionist in the office and so on. I mean, that's absolutely an affront. But in any event, are there any legally justifiable reasons to refuse to appear before a parliamentary committee when a summons is issued?
Well,
assuming they get it.
You use the word legally, so let's go to the context of a court where someone didn't show up when subpoenaed at a certain time. There are excuses and there are explanations. An explanation acceptable to the court might be that, I got hit by a car and I was in hospital. I got caught in traffic. That might not work so well, So there are explanations and there are excuses. And it's the court's judgment as to whether the explanation is sufficient. Now, what that suggests is that there should be an opportunity provided for the person to explain why they didn't attend. So another date is set, and the first question that might be asked of the individual is, why weren't you here the last time we summoned you? Give the individual an opportunity to explain, and then the committee can make its own judgment as to whether that's sufficient for its purposes.
What happens in a case where, as the case of the Prime Minister's chief spokesman, where a summons has been issued, the bailiff can't track down the individual after numerous attempts to issue it? What's our recourse then?
Well, as I said earlier, you could decide on the facts that you have them that every reasonable effort has been made to effect service, and that no further attempts ought to be made, and the person should be deemed to have been served, and proceed on the basis that the person has been served.
Okay, sorry, Mr. Easter, we'll have to know. You can get on again, but I have Madam Freeman.
Depuis tantôt, Monsieur.
In the last few minutes, Mr. Walsh, you've been explaining very clearly what the accountability principle is for the executive arm of government in terms of the behavior of public servants. So ministers have to be accountable for public servants, but not necessarily for their political staff. That's not covered. It's not understood. And the government's position at the moment is to give us the idea that ministers are responsible for the actions of their political staff. I would like to make the following comment. There's a double standard, or two different interpretations at play here, because we remember clearly in the case of the Minister Lisa Raitt when her political assistant forgot some documents somewhere at a TV or radio station that it wasn't the minister's responsibility, but rather the responsibility of the employee who was immediately dismissed. And in the case of Minister Paradis, when Mr. Tournier, and initially the minister didn't know what was going on, and he changed his version later. So we're having trouble following what the government is trying to suggest. To suggest one thing on the one hand and the opposite on the other. So that's my only comment in response to the arguments put forward by the government members here. Thank you, Mr. Chair.
There's a couple of questions that I think we should take advantage of having Mr. Walsh and Mr. Tardy's words of wisdom, because these things don't happen very often. I think the last time we issued a speaker's warrant was for Karl-Heinz Schreiber, which was done by this committee. Prior to that, I think it was in 1913. So it doesn't happen very often. But Mr. Walsh, is it possible to name the government as the party whom has breached the rules or the privileges of the committee?
You say name the government. I mean, there could be a motion of that kind accusing the government of breaching the privileges of the House, but I would assume, depending on the nature of the breach, that the government might well take it as a confidence motion, and you're into a confidence issue.
Sure.
That's where you have to go with the government. You got a problem with the government, you're ultimately in the question of confidence.
Sure. And so that if there was a matter whether you wanted to report, is it advisable that it be a person? For instance, if you had several instances and you were identified, for instance, there's a letter from Mr. Paradis. It raises the question whether or not there is a good rationalization for a committee to report not on a group of people like a government or 3 witnesses, but rather to report individually with regard to specific incidences.
Well, the committee may choose to report with regard to a particular individual minister as opposed to the government as a whole. That's the committee's call. Then in the House may choose to take that incident as reflecting the whole government and choose to frame the motion in the House in terms of the whole government. But I think the committee, as a rule, committees should stick to the facts that they have before them and report those facts, and not go beyond those facts and make inferences of a kind that may or may not be supportable later in the House.
My experience on privilege matters in the House as early as yesterday is that there are many, many elements, and if you just miss one, you're lost. And in that particular case, as you well know, there certainly was a matter where there was a wrong, but one thing wasn't there, and that was that it was not able to, there was no evidence that a member was interfered with in terms of discharging their duties.
Well, you may recall in the ruling of April 27th, where one of the points of the alleged breaches of privilege was a letter from the ADM, and the Speaker ruled, well, I have to see what use is made of the letter. I mean, it's not enough to write a letter stating an opinion. It's a question of taking that letter and using it to interfere with a witness. And there was no evidence of that before the House, and so the Speaker wasn't able to find a breach of privilege.
The reason I'm asking these is that it would appear to me, and I think your counsel has been, not to rely on a single bullet, as it were, but rather to be very comprehensive in the facts and the support for coming to the House, because it is a very serious issue. If a political staff member is in breach of Section 67(1) of the Access to Information Act, which is basically obstructing the release of information, and in fact it goes on to suggest in Section 67(2) that it would be can be subject to imprisonment up to 10 years and/or fines of I think, is it $10,000 or $2,000? In any event, it is a criminal offense. It's a criminal code. If a political staffer, in fact, is found to have been in breach of 67(1), and in fact is subject to a criminal offense. Is it possible for a minister to assume the responsibility for that and in fact be charged themselves instead of the person who did it?
It's hard to address that question without looking specifically at the provision you're talking about, whether in the Access to Information Act or some other provision. But let's say this, at the risk of simplifying matters, two things. One, we're all responsible for acting in accordance with the law, particularly laws of that kind. And secondly, while I made reference to lawful excuse, I did indicate, I think, that there are limits to how that could be used. It's lawful excuse. You can't just say the devil made me do it. You can't just say I did it because I was told to do that. The person who gave the instructions may also be liable to prosecution under the same offense, depending on what the evidence supports. But I don't think anybody can say I did it because my boss told me to, where you're talking about an offense of a kind that's subject to imprisonment as a criminal offense.
Okay, and in the hypothetical that a political staff member in their conduct of their duties actually made some breach or broke the law, is there any instance under which some other person, like their boss, their minister or whatever, could assume the legal responsibility for their actions even though that person was unaware and had no control?
I don't think anybody can assume responsibility for someone else's criminal conduct.
Okay. So ministerial accountability does not, in fact, insulate a political staff member from being charged under the criminal code.
Under the criminal code, no.
Okay.
Point of order, Mr. Chair.
Yeah.
Yes, it's clearly the case that this is not a criminal court, and for you to imply criminality, it goes far beyond your powers as a chair of this parliamentary committee, and probably is also a good illustration as to why the government has made a decision not to allow you to intimidate staff members in person the way you've done indirectly by making allegations, indirect allegations, like you've just done without any basis whatsoever.
Yep.
And I think you know very well that were you to step out of this chamber and make and repeat those kinds of suggestions, you would be the one facing consequences.
Thank you. First of all, it's not a point of order, and second of all, 67(1), in fact, is a criminal offense, subject to criminal sanctions, and I referenced 67(1), but didn't talk about any particular person. The issue is, if there is any kind of a wrongdoing, whether or not, if there is a wrongdoing, and that's why I use the word hypothetical, if there is a wrongdoing by a political staff member, is there any circumstance under which another person could take the responsibility for it if they had no knowledge, but simply because they were the person in authority? Okay, it's the other part of the accountability. Mr. Walsh, when you call a witness, and I'm curious about the justification for calling a witness. Yeah.
I'm just kind of curious how many minutes you're going to take for your own round of questioning, if it's 7, 5, 20, 30?
Okay.
Could elaborate?
Mr. Hoback, it's not a point of order, but there are no members left on the list. And before we release the witness, I want to get some clarification to some matters which I think are going to be relevant to the committee and its further determinations. Mr. Walsh, when a witness is asked for,
Mr. Chair, a motion to adjourn. I didn't raise a point of order.
Yep.
He did recognize me, though.
I know. I just have a couple of more questions, Mr. Polyev, and I think that when...
I don't think a motion for adjournment...
I have the floor, though.
I don't think a motion for adjournment is actually debatable.
No.
Just votable.
No. That was an interruption of my questioning.
You recognized me.
I want to ask Mr. Walsh about committee's responsibility to advise a witness why they're being called and the relevance of their testimony to what's happening.
Good idea. It's not a requisite of a kind that failure to do it exonerates the individual from showing up.
Yeah.
But it's a wise thing to do, certainly.
Okay, because you had mentioned about the relevance or whatever early. I think you call it wrongly called. You said a person would be wrongly called. Could they have that as a reason why they did not appear?
Wrongly appeared, maybe. They came on the wrong day. I didn't mean to talk about being wrongly called. If they're called by a committee, they're called by a committee, but they might show up on the wrong day and get some confusion there. Perhaps I wasn't clear in what I said.
Okay. And the last question is, if the committee got a request that a person appeared and a minister appeared on their stead, is there any reason, and I think you've already answered, but is there any reason why a staffer still could not appear if the matter was administrative as opposed to policy?
If the matter is something of which the individual has some relevant information and is outside the policies of the government, I would think that the individual would be appropriate to call as a witness.
Okay. Civil implications, that was one other that had come up. Madam Freeman had raised it with regard to the service of summonses.
There are civil rules in the courts of the various provinces, but this is a parliamentary matter, and it will be up to the Parliament of Canada, the House of Commons in particular, to determine what shall apply.
Okay. Final comments, Mr. Walsh or Mr. Tardy?
Only that I wish to say that I've enjoyed this very much, but I don't mean to suggest that this. I wish to say to you that the issues before this committee are not ones that are answered in any, how shall I say, determinative way by a law clerk. They are matters that are really for the members of the committee and their political debate, members of the House and a political debate to resolve between them. It's really, in that sense, not something you can look to be resolved by legal answers. But the principles are there to consider.
Okay. I want to thank you.
I need you to pay attention to that. You can look their way. It's okay. I'm tired of the smirks, the grins, and the little mouthing of comments and stuff like that. It's happening over there, Wayne. You don't see it happening over here.
Okay. Order. Mr. Walsh and Mr. Tardy, I want to thank you for this. I want to, but if there's one other matter that well, for the committee, and maybe they may want to ask. It has to do with the request that was made by Mr. Valeri for documents, and the chair is going to need some direction from the committee. We've had a problem. Some have been the documents requested were received in one official language as they're being translated. Other documents have to come either from the minister's office or from the prime minister's office, and despite our attempts, we've been told that they have no authority to release them. And we've written back and we've asked who has the authority to release the documents that the committee requested, and no response has, after what, a week? About a week, still has not been received. I raise this with the committee for the next meeting to advise the chair on what action that the committee may wish us to take. Okay, Mr. Easter.
Could maybe you provide for the committee the letters back and forth on this issue, and we can have a look at it the next meeting. I mean, if we've asked for information, we expect it, but it'd be nice for, I think, committee members to have the correspondence that the clerk may have that relates to this issue, and I think it's easier for us to judge.
Okay, that certainly can be done, and they're not in both official languages, but they can be quickly dealt with and circulated to the committee before next meeting. Okay. All right, Mr. Walsh, Mr. Tardy, thank you kindly for your wise counsel, and you're excused. Okay, colleagues. The
motion to adjourn.
Do you want to make a motion? Okay, I'm recognizing Mr. Polyev.
Motion to adjourn.
I move that we adjourn. Okay, the committee do adjourn. That's not debatable, and I have to put the question immediately. I would ask the chair or the clerk to call the roll, please.
Mr. Poilievre?
Yes.
Madam Davidson?
Yes.
Mr. Hoback?
Why not?
Mr. Rickford?
Yes.
Madam McLeod?
Yes.
Mr. Easter?
Oui.
Here, I'm sorry. Madam Foote?
Yes.
Madam Freeman?
Oui.
Madam Tilac?
Oui.
Mr. Sixay?
No.
We're adjourned.